Okay, so we're also learning that the European Union has lent some support to the LGBTQI community. There's an office that's been put up, and they've reiterated their support. Lawyer Chris Malmhesi is joining us. He is a private legal practitioner with K. Achi and Associates here at Kanda in Accra. Counsel, welcome. Good morning. How are you doing?
I'm wonderful.
We've listened to our former presidents, former gender ministers at the vetting table and all of that. So it does appear that the position of the law is clear. What does Section 104 of the Criminal and Other Offences Act say? Because that seems to be the reference point for all of them.
Yeah, Section 104 deals with matters of uncarnal knowledge. And it typifies the fact that persons, particularly a man, cannot engage another man in uncarnal knowledge, or having sexual relationship which is not derivative of the orifice of a vagina. Now, again, a man cannot engage a woman in similar acts which would not also land in the orifice of the vagina. Now, but where it is not clear is for ladies or women, if I'll put it at that, that women engaging in such relationships. The law did not envisage that. So, apart from the position of it being clear with respect to the examples I just indicated, man, and a woman engaging in those ones, it's criminal.
Sorry, go ahead.
Yeah. So, but if you further come down to Article 12 of the 1992 Constitution,
Right.
it hinges on the fact that there shall be no discrimination with respect to rights, creed, sexual gender, and you have your rights are upheld under the Constitution and all of that. But it is subject to other people's rights, and also particularly subject to public interest. So the question now is, if you look at the establishment of that organization here, we would have to juxtapose the Constitution with the Criminal Offences Act. And looking at the fact that even though they have the right to establish all of these things, does it affect or offend public interest? It's a question of law.
So then for me, on the note of law, is it an offense under our laws to identify yourself as a member of the LGBTQI community, such that I can have a T-shirt with the inscription, I am gay, I am lesbian? Is it an offense under the law?
Okay, there is no express provision as that. What comes to my mind has to do with corrupting public morality. But if that insignia or that inscription is written there, it is not corruption of public moral. It is yet to be decided in court.
Or I wear makeup, high heels, and I'm wearing a skirt, walking around town. I'm feeling free. I think that's me. Am I offending the law?
Well, I mean, we have fashion styles where you have males putting up such clothing, or you have session fashion parades where you have males putting up all of those things. But the important question of law is their establishment, so that if you look at a case like R versus Registrar General, ex parte, Attorney General, it's a UK case.
Right.
You realize that it was a lady who sought to it was a prostitute who sought to establish an organization to propagate things in that nature, and the question of law was whether it would corrupt public morals, whether it would, and to that extent, at the time, it wasn't in the interest of the public, so that establishment was expunged from the records of the Registrar General. The question here is, if they have gone through the registration and cooperation and all of that, and certificates have been granted them, aside registrar general course, they'll be registered as a limited by guarantee to
right.
operate as an NGO.
That's right.
And then they'll proceed further to the social welfare for them to also give them the license to operate as an NGO. Now, if anybody has any issues of law, particularly with Article 12, Article 17, and then the Criminal Offences Act, then you could go to the High Court for a declaration.
I cannot go to the police station and say, look, I've seen this office, I think it's offends my sensibilities. Under which law, for example, can I go to the police to say, I think this office is not good? Because if there's an office that says we are armed robbers and you see people trooping in and out, if you go and tell the police, they would have a law that will back them to go and shut down, arrest people, look for evidence. Can the police move in?
You see, if you cite the armed robbery thing, the police under our criminal code are enjoined to take positive action with respect to where crime is about to be committed, being committed, and has been committed.
Okay.
So that one is a different dispensation. Okay. But you have an organization which has been set up. Now, what are the objectives? Is the objects of the company, is it that to propagate unnatural carnal knowledge in the country? Does it sin against Article 12, which is against the interest of the public? Is it against Section 104 of the Criminal Offences Act 1960? So these are the constitutional questions that if anybody is enjoined to challenge, would go to the High Court for a declaration, attach that particular organization. That is, if the organization is even incorporated as a legal entity.
Okay.
So the question now is whether or not they are properly incorporated.
Incorporated. Okay, so then they would have gone through a certain process, and you would be expecting that the people who okayed the office to be set up would have also looked at what all these laws you are talking about.
Yeah.
That's the assumption. But each time this matter comes up, there is the underlying factor of morals, of culture, of religion. Again, I ask, the argument has always stayed there. Do we have, again, a clear and unambiguous law that states that this is not it? Because if you're saying a natural carnal knowledge, you can have two men hold hands and waist in public. You can have two ladies hit their backsides in public and call themselves Odoyewu. Are they flouting any law?
No, in law, and particularly at common law, the definition of uncarnal knowledge is penal penetration to any of the orifices. Okay. So any of the orifices include the opening of the anal region, and then the mouth.
It means that a lot of people are...
Yes, they are all...
a lot of people are breaking the law.
Yes, it's uncarnal knowledge. The mouth and any other opening aside the vagina. So that's the common law definition of...
So oral sex, forgive me this one, but oral sex is then breaking the law and could fall under this one. People could be punished for it.
Once it's not through the vaginal region or the orifice of the vagina, then it's deemed as unnatural.
Have we gotten to the point where we need that clear, unambiguous law? Because what you're saying is more like a broad spectrum kind of legislation. Have we gotten to the point where we need a clear, direct law to also help you lawyers? If any of your clients comes up and people want to lynch him, and he escapes.
If when it comes to lynch, our criminal laws are against assault and battery. You also go to our Domestic Violence Act. It's also against such acts. So if you suspect somebody to be LGBT and you attack that person, that is against the law. So the whole point is, if somebody is caught in the act, just as I began by explaining that if it is a man and another man, that one, the law says, it's uncarnal knowledge to have sexual intercourse because the orifice of the vagina is absent.
Okay.
Per the common law definition, it's absent.
Okay.
Now, they are going to do anal regions. If you have a man and a woman doing anal penetration, that one too is on carnal knowledge, because it's again not the vaginal region. Now, but the law did not go further
for a woman to
a woman. A woman. So for the lesbians, that portion is not captured under Section 104.
So then we need a definite law to be able to deal with
that. That is it. I mean, we need the definite law to capture all of this, for the country to know whether we are fully for. It must be expressed whether we are fully for or fully against. But as it stands now, it covers an extent of LGBT, which says that the country is not for. It covers up to, with the exception of the lesbians.
Okay.
It captures up to. Now, I further went on to cite Article 12 to you, that in as much as your rights and freedoms, you know, you have your rights and freedoms to sexuality and all of that. So to set up whatever organization you want to set up, it is subject to the rights of other people, and then in the interest of the public, so that if whatever you are doing is against the interest of the public, then you need to go to court for a declaration for a member of the community, and a member of the community going to court. One of our sources of law is customary law and Article 11, and that posits squarely that I mean, we also derive our laws from community-based laws, customs, traditions, and our folk laws. And that also informs our laws, because you have, when the court is taking decision, it also looks at the customary law prevailing.
Now, Ghana, talking about that, Ghana is a member of an international community.
Yes.
We belong to ECOWAS, AU, UN, EU. We associate with all of them. This body that has set up the office has the backing of the European Union, and we all know what pact we may have signed with them. Should we be looking at ourselves as an international, member to an international community, and all the things that we may have signed on to, human rights, blah, 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 or we should just be selfish and look at our laws and traditions and customs as it is here in common law?
The African Commission, sometime in 2014 at Luanda, passed the resolution with respect to human rights and people's rights, with respect to all of these gay rights and all of those things, for member states to adopt and to see how best they can practicalize some of these things. Now, it's dependent on individual states to see how they can make these things work. As we have on our statute books, Section 104 is very clear, given all the examples I've given. And to a very large extent, if any member of the society, because our courts have not been, or our courts have not tested, individuals are to take matters to court for the court to test or to give its opinion on these positions. Now that it seems as if I'm acting on the presumption that it has been incorporated under our laws. If it is so, then it behoves on an individual to go to court, whether the High Court or the Supreme Court, for a declaration or interpretation. And amongst other things, we will join that organization and then the Registrar General's Department, to the extent that where the declaration becomes successful, and you have the Registrar General also being part of it, further orders that will be made, because you'll be seeking declarative release, you also be seeking orders from the court. And the orders, you are successful, will be that it be expunged as an incorporated company based upon all the laws that the court would espouse.
We have to
that is against Article 12 because of the public interest. So it's a broader consultation, and it is for individuals who think it offends the public interest to take it up.
What should Parliament be doing now? That's my final question to you.
Parliament can only move, or they move in the public interest. So for now, I believe we need to test the law for Ghana to come to a certain position. And when we have case laws coming in, it would affect amendment of the act, whether we maintain it as that, and whether it should go to left or it should go to right. The law The law now is that we need to test it for us to know our position.
Thank you. Chris Malm-Hesse, Liberation Chris Malm-Hesse is a private legal practitioner here in Accra with K. Achi and Associates, and for your legal needs. He's been explaining to us what the position of the law is, and you heard him clearly. So let the debate continue in your homes and offices, wherever you may find yourself. This is just one of many of the conversations to come. But thanks to Sona Fashions in Tamale for my outfit this morning.